The important part, that is part 5, executive the governor. This part is extremely important in a certain perspective that I will indicate, which is one of the arguments which I propose to raise. Now, who is the head of the state? It says the head of the state shall be designated as the governor. There was a change earlier. It was first Maharaja, then Sadr Riyasat, now it is governor. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through subordinate to him in accordance with this constitution. Nothing in this section shall be deemed to transfer to the governor any functions conferred by any existing law on any other authority, or prevent the state legislature from conferring by law functions on any authority subordinate to the governor. Appointment of governor. The governor shall be appointed by the president of warrant under his seal, hand and seal, provided that the person holding office as Sadr Riyasat immediately before the commencement of the Constitution, Jammu and Kashmir 6th Amendment Act, shall on such commencement be the governor and shall, subject to other provisions of this Constitution, continue to hold office as governor until the remaining period of his term. The governor shall hold office during the pleasure of the president. The governor may, by writing under his hand, direct the president to resign his office. Subject to foregoing provisions of this, the governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that he shall, notwithstanding the expiry of the term, continue to hold office until his successors enters upon reference. Qualification: no person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 30 years. Conditions of office: the governor shall be a member of either of the office. Governor, he shall be deemed to have vacated his seat on the house in the house on the date on which he enters upon. The governor shall not hold any office of profit. The governor shall not be entitled to such emoluments. Now, what is important is in this, the oath which he is required to take. That is section 31. The governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court, or in his absence, the senior-most judge of that court available, on oath or affirmation the following form. That is to say, I so and so, that I will faithfully execute the office of governor or discharge the function of the governor of Jammu and Kashmir, and will, to the best of my ability, preserve, protect, and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of the state. And the governor stabbed the people of the state in the back. He committed serious breach of the oath by making a recommendation to abrogate Article 370, which he could not do. Had he been a sitting governor, perhaps impeachment motion could have been moved against him. He is to uphold the Constitution of Jammu and Kashmir, and he destroys it by his recommendation to the president, that you apply all the provisions of the Constitution of India to us, which even the Constituent Assembly did not do. He requests the President of India, you change the Constituent Assembly to Legislative Assembly. And the President of India is pleased to accept the recommendations of the governor when he acts in breach of the oath of the Constitution of Jammu and Kashmir, which is serious constitutional misconduct committed by the governor. And in this particular case, there is no evidence produced. Nothing is stated in the counter affidavit. When was the recommendation made? Who made the recommendation? At whose instance the governor made the recommendation? I have a very serious issue to submit before this honorable court with regard to this role of the governor in making a recommendation when the state was under president's rule. Then, sir, C 35, Council of Ministers to aid and advise the governor. Council of Ministers to aid and advise the governor, section 35. There shall be a council of the chief minister at the head and aid and advise the governor in the exercise of the functions, all functions of the governor except those under, now see this is important, all functions of the governor except those under section 36, 38 and 92 shall be exercised only on the advice of council of ministers. Means that he had a subject to satisfaction in respect of three provisions, 36, 38 and 92 and none else. He cannot act of his own. Under any provision of the constitution of the state, and much less he could act under Article 370 in making recommendations to the president. And this governor has been spilling beans all over the country. According to one of his press statements, he was asked to sign on the dotted lines. That you lordship will find from the records because we have no access to those records. (36) is the appointment of ministers, responsibility. Then appointment of Advocate General, conduct of business. Now composition of the state legislature. We have the seats reserved for the territory which is occupied by Pakistan in section 48. Kindly see this. We have then composition of the Legislative Council. We had a bicameral legislature, assembly also and council also. That is section 50. Then CSR 51. Qualification for membership of the legislature. A person shall not be disqualified to be chosen to fill a seat in the legislature unless he is a permanent resident of the state. They alone can be the members of the legislature. Then so directly kindly go to section 92. Obviously, these provisions are not in the Constitution of India. If at any time the governor is satisfied that the situation has arisen in the government of the state cannot be carried on in accordance with the provisions of this constitution, the governor may by proclamation assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by anybody or authority in the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of proclamation, including provisions for suspending in whole or in part the operation of any provision of this constitution relating to anybody or authority in the state, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in the High Court. Any such proclamation may be revoked or varied by subsequent proclamation. Any such whether varied under sub 2 shall accept when it revoking a previous ceased to operate on the expiration of 6 months from the date on which it was first issued. If the governor by a proclamation under this section assumed to himself any of the powers of the list to make laws, any law made by him the exercise of that power shall subject to terms thereof continue to have effect unless 2 years have elapsed from the date on which so and so. No proclamation under subsection 1 shall be issued except with the concurrence of the President of India. Every proclamation under this section shall, except where it is a proclamation revoking a previous proclamation, be laid before each house of the legislature as soon as it is convenient. Now, what's important in this is the same thing as in Article 356, that when you cannot carry on the government in accordance with the provisions of the Constitution. That is the subject of 92, and that's also the subject of Article 356. Now, the question for Lordships is that on the basis of pre-existing constitution. If the government cannot be carried on, whether the constitution itself should be changed, or you have to see only that the government is not being carried on according to the constitution, which was prior to any alteration or change made in the constitution. My submission is that nothing can be done when 92 is in operation or 356 is in operation, because the subject is only that governments cannot be run according to the constitution. But no power vests in any authority to amend the constitution, whether it is 92 or 356. None. Just on an analogy, I'll just seek your Lordship's consideration to Article 34. Of the Constitution of India.
Article 34.
34, yes. Just by way of analogy, I'm showing. Notwithstanding anything in the foregoing provisions of this part, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was in force. Or validate any sentence passed, punished, inflicted, forfeiture, ordered, or other act done under martial law in such area. If such a situation would arise, would this court countenance that the chief martial law administrator will abrogate the Constitution of India because it doesn't suit him? What is the power with it? I'm trying this as an analogy that even if there would be a case of martial law, the Indian Constitution, the Constitution of Jammu and Kashmir, do not contemplate, envisage, nor can be conceived of that during the operation of 92 or 356, any change in the constitutional relationship can be made. That's my contention of the Lordship's consideration.